I'm very happy to introduce you to this last panel. My name is Monika Hupfhoff. I'm a lawyer and trained mediator, and I'm having a strong focus on IP and life sciences. I'll keep the introduction really short in order to save enough time for the discussion going on. On this side, it's Annette van Haft. She is an independent arbitrator and has really extensive experience as counsel in common law and civil law jurisdictions. And I'm sure she will give us a great contribution and a view on her experience in life science cases. On the other side, I have Professor Dr. Peter Meyer-Beck. And I'm sure he is giving us his view on pharma, IP disputes, and in particular, the guidance. Altogether. And in particular, the necessary guidance by higher courts, and as his view as a Supreme Court judge. And here we have Gavin Pope. He's an accredited mediator and has extensive experience as head of legal in litigation cases as well as arbitration and mediation cases, and I'm sure he can give us a great view from the in-house perspective. So I thought I would like to start with one case I'm involved in at the moment. It is a quite complex case because it's a dispute resulting out of a drug development and license agreement. And there is an arbitration proceeding already going on, but the parties came to the conclusion that it will be a lose-lose situation if they stop the development, so they concluded an enabling agreement in order to carry on with the drug development during the arbitration proceedings. And in parallel, there are settlement negotiations going on and attempts for mediation are made. And I do know there are other cases where things are even more complicated when patent validity or infringement proceedings are initiated in parallel. So I'm really interested in your views on such cases. Maybe Annette, you would like to start?
Yeah, I'm happy to start with that. I have seen cases where parties went a little bit overboard in the sense that they started infringement cases basically related to a period after the termination of a certain license agreement, but they also started arbitration proceedings related to the license agreement while it was in place. And we then ended up running a fairly costly arbitration together with fairly costly proceedings before the state courts. And that became really very messy. The cases, in that case, the state courts were in the US. So there was a case in Texas. There was then another case in Northern California. They got joined. We got to the point of anti-arbitration injunctions that needed to be pleaded. And honestly, the lesson I learned from that is think very much what is most important to you, the infringement, or whether you really want to discuss the license and whether infringement is part of that discussion rather than a separate one.
Thank you.
As a German federal judge, I have to be much in favor of court litigation, but I think it became clear from the discussions we had today, there is not one answer to the question, is court litigation better than ADR or vice versa. Traditionally, I think license agreements are a favorite field for arbitration, sometimes mediation, and patent infringement used to be the field of court litigation. SEP cases have changed a bit this field of best choice. And I think another aspect, it depends on the perspective, what is the best way to deal with disputes like these. The public view might be that ADR is less transparent, although transparency may be improving, but nevertheless there is less transparency. There is less public surveillance, so to speak. You all know about the discussion we had in Europe about the TTIP agreement, especially when it comes to the question of investor protection, arbitration courts, and that is my for my personal view, a very important point. There is less, if many disputes are treated by arbitration bodies or even by mediation, there is less guidance by the state courts which comes from those cases which are tried and which are discussed, even discussed between the different national courts in Europe or on a worldwide perspective. Of course, from the private or the industry perspective, ADR might be hopefully faster, even cheaper, although I learned from sometimes it may be the longer the cheaper, or whatever. The procedure may be more appropriate than the court procedure which is available. You may have more competent arbitrators if you have not if you haven't no specialized judges in the courts. And of course, which is especially important for the SAP issue, you have a wider, you may have a wider range of options as to the remedies and as to the issues covered anyway by the solution found. And same is even more true for mediation, because we have a you can do everything what might be useful to solve the conflict between the parties. So I think mediation is a different thing anyway, because that's not about a legal solution of the case, but of solving the conflict between the parties, and that is, I think, another issue.
Right. Thank you. So again, speaking in my personal capacity and not on behalf of Novartis, I think, firstly, I would be happier to have this dealt with by arbitration than in state court. That's certainly true for a number of reasons. I mean, firstly, it doesn't sound like the sort of thing that I'd like to have in public. It sounds a real mess, and I don't want this to be more publicly known. I think secondly, given the complexity of it, I think and the multi-jurisdictional aspects of it, I think that is something which could be quite well dealt with in arbitration. Having said that, I mean, it sounds to me very much like the type of case where mediation could be helpful, or at least could have helped at an earlier stage. I mean, I guess that would be my main concern is, are we already too far down the road to actually engage meaningfully in mediation? But I think mediation would bring a number of potential benefits. Firstly, I mean, the parties are not then restricted to whatever remedies are available to the judge or the arbitrator. And I think in this type of case, that's really quite important. There's obviously been drug development already. There's an ongoing relationship that's going to need to happen into the commercial phase now, into the marketing of the product. So it's a relationship that actually needs to be maintained. It's not something where a win or lose is actually ultimately going to help either party. So to my mind, it's in that sense ideal for mediation. The difficulty then is creating an environment in which the parties, given all of the animosity that there's obviously been, can actually sit down at the table and have that type of discussion. And I think that then probably becomes more actually of an in-house problem within those companies as to how they can get themselves to that mindset where a mediation would be feasible. But to my mind, that would be the best, worst option in that case.
What I didn't mention before, the dispute is between an Asian company and an Austrian company. Do you think the cultural aspects play a role too? Or is mediation even more suitable when we have such different cultural aspects involved?
Depends on the mediator.
Yeah, I think that's probably true. I think it is an opportunity then to have someone, hopefully a mediator, who is cross-culturally experienced and can actually help with that. I wouldn't say that should. I mean, it is obviously more difficult conducting mediations, particularly if you're having to do it through translators as well as on a normal one-to-one basis in the same language. That definitely makes it more difficult. But frankly, I mean, that's something which the parties are going to have to master anyway if they're going to make this relationship work, which I assume, given, again, the situation they're in, the cost already incurred, and their potential future relationship, they need to solve that. So, yes, it makes it more difficult, but I wouldn't say that it should be a bar to it. And frankly, it's going to be a difficult part of arbitration as well, potentially.
If I may pitch in, I think mediation can work very well, for example, in situations where there are cross licenses or various issues. So it's really easy that you what they call enlarge the pie, that you include other issues as well. Or, and I think your case is almost like a lose-lose situation, a case where, in fact, neither a court nor a tribunal can really give what the parties really need. The outcome is always going to be unsatisfactory. In that case, I think the parties need to try to find a solution themselves, because it's always going to be better. I mean, also an arbitrator, maybe I do agree that arbitrators, for example, in the FRAND space, may have more space to structure a proceeding in a different way than a national court could do, and have more flexibility there. But as an arbitrator, things are limited. You're not a mediator, and you're not going to bring in certain commercial solutions that only the parties can devise. So, yeah.
Mm-hmm. Maybe one more question relating to that process of having the arbitration proceeding going on, the development being still carried on by the parties, and on the other hand, the attempts for settlement negotiations and mediations. Do you think that there is a certain point of time when it is too late to initiate the mediation proceeding or to try to settle a case?
I can take that first of all. So I think the answer is no. I mean, the key thing for me for mediation is actually having the parties in a position where there is a mutual commercial benefit to actually getting to a resolution relatively quickly. And it may be that at various parts, it may be, in fact, that at the very beginning of this process, that wasn't the case. And for various different reasons, maybe that wasn't in the interest of both parties. It sounds from the limited facts we have now as if they are at that point right now. So whilst I think from a personal perspective, the individual's concerned, yes, there may be a loss of face, yes, there may be more ego involved than before. In that sense, the stakes for individuals are probably higher. Actually, from a company perspective, it sounds very much as if they are in a place where, frankly, that type of resolution is the only option. And I think that hopefully will galvanise them to both be in the same position to actually be able to come to that kind of judgment. So I don't think it's ever too late. I think it becomes more difficult. It becomes more difficult because costs being incurred, which has actually pushed the parties further and further apart in terms of what they may be willing to settle at. Having said that, in this case, it's actually perhaps now bringing them back together again because there's no alternative.
I've once had a case, but that was when I was still a case handler at the ICC, where I actually got a call from the parties when I had the draft award on my desk. And it was a license agreement related to car batteries, but really on the last minute, the parties had reached a settlement, and they asked us to just please keep the award and never have it issued, which is what we did.
As an arbitrator, how would you handle it if you have the feeling that a settlement would be much favorable for the parties? Would you give them guidance, or would you just stay out of that and say, I'm not going to get involved.
I think as an arbitrator, you need to be very clear about your role, and it's difficult to mix the roles of mediator and arbitrator. Arbitrator, your mission or your mandate is to decide a dispute, and you do that on information that everybody has, that's on the table for everyone. As a mediator, you can get ex parte information that you will not release, etc. So those roles are difficult to combine as such. But I think as an arbitrator, you don't necessarily have to step in and suggest you're the mediator. If you have the impression that this is important for the parties, you can ask. You can ask at the first case management conference whether the parties see any need to suspend the proceedings because they want to engage in talks. You can indicate that if the parties at any point feel this need, all they need to do is signal it to the tribunal. And so there are various ways to deal with it without overstepping your mark, while you can still give the signal to the parties that in your mind it looks like this is something they may be able to work out yourself. But you should also be very careful, I think, because as an arbitrator you never get 100% of the information. Parties are presenting their case, so there are lots of things you don't know. So you need to treat carefully. I don't think you need to back away from it completely and just carry on. You can bring up the subject, but I would be very reluctant to step in as a mediator if I'm appointed as the arbitrator. I mean, you're one or the other.
Okay, thank you. Yeah.
I think the same is true for court proceedings. In many cases, settlement is more favorable than a court decision for the parties. It may depend a bit on the stage of proceedings, and from a Supreme Court's view, it's we very often see the public interest in the case to be decided, but at the very end, it's the party's interest is the most important aspect, and if it's for the parties, it's the best solution to settle the case. That should be done. FRAND cases might be a bit problematic because of competition law which is involved. So we have to care about that the settlement is not against competition law, but there is some. Of course, there is some discussion. It's the same issue we discussed on the other panel. Can the decision of the arbitration body be contravene competition law? Yeah. It's well established that even a competition law case may be settled by the parties, and if it's a reasonable solution and it's within the range of reasonable doubt about the legal answer on the related questions, it's possible to negotiate the case, and it's possible to come to a settlement in court proceedings as well as in arbitration proceedings. So I think that's quite important that we leave that room and do not think that there is only one solution which is in accordance with competition law, because that makes it even more complicated than it is anyway.
And I think in addition to the duty there of the arbitrator, perhaps to suggest mediation as an alternative, I'd also make a plea then, I think, to you, and most of whom are external counsel, external practitioners, to actually consider yourself making that suggestion. And it's often described, I think, as the elephant in the room here, that obviously the significant fees to be made from litigation, from arbitration, and if a quick settlement is achieved through mediation, that's not necessarily in the commercial interests immediately of the law firm concerned. And we appreciate there are billing targets and there are profit margins and so on. But I think from my perspective, I think there are three good reasons why you should do that as external counsel. I think firstly, at a spiritual level, because it's the right thing to do. I think from a professional perspective, because ethically it's your duty. If that's in my interest as your client to mediate, to settle, then it's your duty then to inform me of that. And I think if those are too aspirational, then I think at a third level, I think commercially, frankly, the short-term loss that you have from that advice will, I'm sure, be regained in the trust that you gain with your client and the future business that's likely to afford. Because frankly, if you advise me against your own interests, basically, to go through a mediation process that settles, that builds a huge amount of trust. And from my perspective, I mean, that's very, very important. And as we look to sort of build partnerships with the external law firms that we use, I think that is really instrumental, I'd say, in that type of relationship. So I think on those three levels, it really is worth your consideration of advising mediation, even though that may not be in your direct, immediate interests.
So what is your experience? Because one issue at the moment is too whether it is better to involve the counsels and like lawyers in the settlement negotiations or to keep them completely out. And there's always that question of confidentiality. Everybody is afraid that anything dealt with in the mediation will be used in the arbitration. Yeah.
So, I mean, I think the confidentiality point is definitely a major concern. And I think it's difficult. Having said that, I mean, my experience is that actually, in many cases, getting the lawyers out of the room when it comes to that type of mediation can actually be helpful. You want certainly to have robust legal advice for whichever commercial people are actually going to make the decision, so they understand their rights, they understand ultimately get the best picture they can. But I think often it's very helpful to remove people who have been entrenched in that litigation, arbitration for a long time, who have strong views about the case, who have perhaps an emotional attachment to it. I mean, but I'd say also that internally, frankly, it's not helpful having people, again, who may have an ego, who may have basically a personal engagement with a dispute. The more it's possible to escalate it above that level to people who are more dispassionate, who can take a broader view of the overall issue, I think that's helpful. So I don't think it's just about having lawyers, and that means in-house lawyers, external lawyers. I think it's rather trying to get to more dispassionate people who can actually make a sensible judgment.
Well, there may be different interests involved, but I would like to stress that sometimes you have a case where it's not only in the public interest to have a state court decision, but at the very end also in the interest of the parties. For instance, the Pregabalin case, the decision of the UK Supreme Court in the Warner-Lambert case. There were several issues of public interest. The question of the plausibility test. What does it mean? Plausibility of the result of using the technical teaching of the invention, making it plausible that the invention works, to which extent it works. That is a very important question. Or same other point in this case, second medical use. What is necessary? Which requirements have to be fulfilled in order to decide in favor of the patentee, in order to find the patent infringed. In the unfortunately, there was not a uniform answer on the. Perhaps some mediation was might have been a good idea, but at least it is a contribution to the international discussion. The German several German decisions were analyzed in the several judgments of the Supreme Court justices. And they were analyzed in impressive depth, not only the well-known concept of sinnfällige Herrichtung, outward presentation, or to put it more, put it in a clearer way, only packaging does.
Yeah.
And that is quite important for the harmonization of European law on our hard way to common understanding of these provisions. And at the very end, I think it's also important for the parties who have the next case. Of course, they can mediate the case and find a solution which does not care about the legal questions involved and look what makes sense for the parties. But for arbitration, at least, I think it's necessary that we have some more or less clear rules how to deal with these issues, and then I think that is quite important, especially in the field of healthcare and pharma, and we are talking about.
So I think we have a common understanding. The sufficient case law is really important in order to be able to have or decide on in arbitration proceedings. But maybe another question would be, do you see any possibility that a certain guidance could be established by arbitral tribunals as well?
I would like to make two comments. I think when there is established case law, that's obviously helpful for arbitrators and judges alike. It makes it easier when there has been a debate and a decision, because otherwise you have to invent the wheel each and every time. So it's helpful. If it's not there, I think a tribunal obviously can come up with a solution and should keep in mind it's deciding only the parties' dispute. But I do agree there's this tension between what is decided privately and confidentially, and that we also need information in the public domain, which will help us harmonize, or at least will force people to clarify if and when they take a different position to what seems to be generally done. So that's a difficult issue, I find, that you find both in the biotechnology and the pharma field and in the FRAND field. Can arbitration contribute to a body of case law? I'm relatively skeptical about it. The ICC has changed in its note as of 1 January the way it deals with its awards, and it has made known that it's its general intention to publish a large body of its awards. And one of the reasons that, among others, Alexis Moore has invoked, he is the president of the court, is that he thinks that there are basically two reasons. One is all the recent criticism on investor-state arbitration and the alleged lack of transparency everywhere and important public policy issues being decided behind closed doors, which is obviously something that the ICC is very concerned about, because they're worried that this concern that there is with investor-state arbitration will ultimately be carried over into the field of commercial arbitration. So in a way, it's I think this has been decided to how can I say, preempt that argument. And the other idea apparently is to help establish a body of arbitral awards that other arbitrators can look at for guidance. Now, one of the difficulties, of course, is that as an arbitrator, yes, you're bound by the contract. Yes, you're sitting in a certain country with a certain seat, and they will have an arbitration law. But to what extent is something that one of you decided in a different country with a different contract? To what extent can that be binding on me? I can very well see that it's helpful to see what others did and how they reasoned and how they got there, but it's not necessarily binding. So arbitral precedent is a difficult concept. And then there's obviously a last point. So while the ICC has announced that they have this intention, they have also realized that a lot of the parties come to arbitration because of confidentiality. So they give the parties the option to opt out. And so how much or how many more awards will ultimately be published because of this change, that's very much everyone's guess. So I'm afraid I don't have the solution. Sorry. Sorry. Disappointing. Really disappointing.
So
I think
it stays with the state court.
I think it comes as no surprise that I'm not very optimistic about arbitration precedents. It's difficult enough to find common ground. I worked really hard to find a connection between the pregabalin case I wanted to talk about and the topic of our panel, but
It's definitely there.
it shows the problem because the UK Supreme Court considered the English law of torts and compared it with the German law of torts and compared the English understanding of second medical use claims with the German understanding of second medical use claims. Is it a process claim or is it a purpose-bound substance claim? Yeah, so the outcome was the understanding is different. At the very end, it may be not a question of German and English or British law, but of European law, of the European Patent Convention, because the Swiss type claim was an invention of the enlarged Board of Appeal to resolve a problem they saw in granting use claims on medicaments. The Bundesgerichtshof has said some years before, in 1983, I think, in the hydropyridine case, there is no obstacle to grant a claim to use of a noun compound for treatment of an other disease than the disease treated before with this very same noun compound, and the result is kind of mess because we have now we got rid of it, but nevertheless for many years we have still to struggle with these kind of claims which pretend to be related to manufacturing manufacturing a product, although it's not really the case, because all is about treatment. And so that I'm afraid that arbitration cannot really contribute to solve problems like this.
Although there is still a view that mediation would be one of the best solutions for cross-border patent infringement cases where we have different proceedings in different jurisdictions involved.
It could be. I mean, perhaps I want to first just deal with the previous point, which is also that in addition to all of the problems highlighted, I think if you read a few arbitral judgments, you'll appreciate that they're not all written to the standard of a Supreme Court judgment. And I think that also has an impact in actually how usable they are as a source of precedent. And I just feel if you look at the value of that versus the loss of confidentiality and the value that gives to companies coming or individuals coming to arbitration, to my mind, it doesn't make that much sense. I think if it was possible to distill out of the awards, perhaps some of the key principles, that might be useful, but in an anonymous way, I think. Otherwise, we would simply more likely choose an alternative arbitral body that guaranteed the confidentiality. And then coming to the IP question, I think it depends an awful lot on whether or not, again, it's in the commercial interest of the parties to settle. And one of the biggest problems, obviously, in that sphere are preliminary injunctions. And whether or not a preliminary injunction is granted or not can then have a huge bearing on whether or not actually it makes sense for both of the parties to come to a settlement before the final trial judgment. And I think that, unfortunately, is a kind of commercial reality of it, that in many of those cases, once you have a preliminary remedy, actually, it essentially negates the ability of the parties to sensibly mediate before you actually get to trial. But I think in other cases, I don't see why not. I mean, certainly, you can get over some of the cross-border challenges that you have there by having the parties come to a settlement between themselves, basically, which can be all-encompassing in that sense. I don't see why it shouldn't be used.
No, I agree. No.
Okay. Maybe just we are in this field now, the Unified Patent Court foresees for some mediation, arbitration and training in mediation. It is still a bit unclear how the whole thing would work out, but I would be really interested in your views on whether you think this is a good implementation or...
It's very hard to have a view in the sense that it's all fairly vague apart from this Article 35, but it gives you in the UPC treaty, but it almost raises more questions than it answers. So sorry, we're adding more problems. It's horrible. Nobody's going to go home with any solution today. We've just added more problems to it. There's still a tremendous amount of work for all of us. Let's take it positive. But it's very. I've been puzzled by this article ever since it came out, which basically will tell you that there will be an arbitration and mediation center will be established. It will have seats in Lisbon and Ljubljana, and for those of you who arbitrate less regularly, they are not the most well-known seats, and so it raises all sorts of questions. Is this just the place where this institution is going to establish itself? Will there be default rules that in case a party forgets to pick a seat of an arbitration in the arbitration clause that you end up in either one, and how do you know in which one you end up? Is that a good idea? Because the reason why a seat of arbitration is important is that it will give you a legal framework. It will be that arbitration act that applies, but there will also be those courts that will be behind annulling or upholding the award. So it's helpful to have robust courts that have experience, that will not just annul awards that go against their nationals. On the other hand, that will act if there's something very serious, like a major breach of competition law. So it's very difficult to see how all of that is going to work. And another issue is it's very easy to make an arbitration center. You can set up one. I would almost say within a week you can establish a new arbitration center. You may need 2 weeks to get the website, but you copy paste from the various rules that are available. Honestly, if you set aside some time within a short period of time, the real issue, of course, of an arbitration center and the reason why you take certain rules is that you know that they have certain experience, or at least have the people involved that can carry the institution and that make it a trustworthy choice. And that is the real challenge in establishing an institution. And so there as well, I think for the moment we're in the dark. Yeah.
I'm sorry, there's one other issue in relation to that in the Unified Patent Court as well, which is that this arbitration centre is established under the UPC agreement, and therefore, what is its jurisdiction? Surely its jurisdiction is limited only to those patents over which the UPC agreement relates, and therefore you could not, for example, get a multi-jurisdictional award which dealt with patents outside the outside the EU. I mean, indeed, patents. Other designations of EPO patents outside the EU. So I think it's a very weird concept.
Here's a gadget. Here's the gadget.
As I am not the UPC specialist in my court, which is Klaus Grabinski, I hand over to Robin.
This arbitration centre based as it is in Lisbon and Hungary, I think in Hungary, isn't it?
Slovenia.
Slovenia, yeah. Will never ever have anything to do. Nobody can make you go to it. If you want to arbitrate, nobody will choose this centre. This is a politician's rubbish. And with all
That
due
is quite
respect,
more clear than my answer would have been.
and with all due respect, it's produced a bunch of rules and whatnot. I think Michael was concerned with them and gone off and had lots of wine in various good places. But it will never, ever, ever open its doors, even to the beginning of the talk of an arbitration. And that must be true, because no company will say, I want to arbitrate there. And you need two companies to say they want to arbitrate there. So you want two people who won't ever have it. There will be panelists appointed. Oh, yes. I shall probably be one of the panelists. Michael will be another. We'll be available.
Lisbon would be good.
We'll be sitting in Lisbon in springtime waiting for the cases to come in.
Or Ljubljana.
Yes.
Will it be honest,
I think
okay?
it also raises an interesting issue then about the procedural law that you'd need to apply, because presumably then it would be Slovenian or Portuguese law, and any appeal then also would need to take place.
Well, that's just, well, I mean, appeals to,
That's not
most people are not specialists in the jurisdiction of the Slovenian and Portuguese courts in relation to arbitrations.
Right. Right.
It's never going to happen.
It's obviously a very high margin business where IP is the main asset, in particular its goodwill, its reputation, and of course its patents. We've seen in the press quite recently some crises, I would call them, in particular in relation to the opioid crisis in the US and the likes of Purdue being sued by way of class actions. Do you think that because of the specificities of the pharma industry, and in particular its of the utmost importance of the reputation of a brand and the goodwill, Purdue, for example, could have dealt with these claims in a more astute way by actually resorting to ADR, as opposed to having it splashed all over the press that they were the objects of many class action lawsuits. Actually, my question is to you, Novartis. What do you think?
Well, I won't be answering on behalf of Novartis.
Yeah, I know you said that, so
but
putting you on the spot.
I mean, as a personal opinion, I think it could have been handled a lot better, certainly. And I agree. I think, given that the pharma industry has suffered somewhat in terms of reputation over recent years, I think that is something which we need to work to improve. And that type of case clearly is not helpful in doing that from an industry perspective, let alone.
Do you have sometimes your PR and communication press people calling you in the legal office and saying, you need to find a way to resolve this in a confidential manner? Please work on it so that it's not going to be splashed all over the press. Do you sometimes have this type of conversations, even though you are not speaking on behalf of Novartis?
Well, I'm not going to answer that from a company perspective, but from a looking at it from the company concerned, theirs perspective. I mean, yes, if you look at the overall value of the case is, yes, the financial value of the claims that go out, but a huge part of it is also then, it's the brand, it's the reputation, it's the trust of patients, it's the trust of the healthcare professionals who are actually prescribing those, it's the trust of the government and others. And all of those can be lost very, very easily. And I think that type of case is a good example of where actually failing to take that into account, and perhaps, I mean, I don't know, from a legal
So how would you have used ADR to deal with this PR crisis in a more astute way, in a more commercially savvy way?
Particularly in the US, it might even be an opportunity to actually start with mediating with some of those concerned. I mean, that's something which has been seen, both in cases of product liability, also in cases of labour dispute and other areas. So from that perspective, there's no reason why that couldn't be a starting point. Failing that, I mean, yes, taking the dispute out of the public domain into an arbitration process might also be a good way of dealing with it. Where also then, if you do settle, and hopefully you'll be able to settle given the nature of those claims, you can do it in a confidential way that's not necessarily going to have an impact more broadly than those cases concerned. So there's certainly a big advantage to confidentiality in those cases. And it's not just a matter of I would say, salvaging the reputation. It's also a matter of trying not to set precedents for other cases which may be somehow related.
Yeah, but you can't force an NDA on a customer, so therefore they also might want it to be splashed in the press, so you might have to pay up.
True.
Okay.
True.
Thank you.
That's absolutely fair.
Sorry, I'm David Rosenberg. I used to be with GSK. ADR has rarely been used, I think, in our industry in disputes with generics for fairly obvious reasons. But I have a sense, or it's a feeling, that we may see more and more of it because we're seeing more and more innovator litigation. As you said, preliminary injunctions when you're against a generic, very important. In most cases, innovator-innovator disputes are just about money, or a cross-license or whatever else, not injunctions. The UPC, to the extent that patents aren't opted out, will have a massive impact on whether, if we lose a case in the UPC across Europe, it's the second biggest market in the world. We don't want to see that. And for the very reasons, Peter, that you were saying, keeping these things private from the industry's perspective and inter partes might be very, very useful indeed. So I sense that we may see more or ADR, at least in innovator and innovator disputes, and actually in biosimilars, because the dynamics around the competition are so different.
Right.
So I think we may see actually quite a lot more of it, sometimes for the reasons you don't want to see, Peter, which is confidentiality. Confidentiality and the inter partes effect, which is very important. I'd much rather Novartis knocked out a GSK patent as between us than as against the world. Sorry, I would have done not speaking for GSK. But I sense there might be incentives now, more so than in the future.
I think that's absolutely right. And I think as we move move away from many of the small molecule disputes that we were seeing before into much more complex biological products where the patent issues are much, much more complex. The need for cross-licenses is much, much greater. And I think then it becomes, it's not a win-lose basically on a compound patent as may have been the case before. It's much more complex than that. And I think those are, I agree, the types of discussions, again, you don't want to have in public. And given the complexity of them and how wide-ranging they are probably best dealt with by some form of arbitration or ideally even a mediation between the parties if possible. Mm. And the other thing I suppose on mediation, the difficulty is, given the competition aspects of patent settlements, I think for a short period of time there's a move slightly away from those types of settlements simply out of fear that you're going to get into an anti-competitive situation through those. I think now there's sufficient case law on those that I think parties generally feel a bit more confident now and comfortable about entering into those, and I hope that continues, because if done in the right way from a competition perspective, I think they can be very valuable.
I wouldn't agree with that. I think there are real dangers from the competition authorities still. I don't think it's proceeded. I've heard of a trademark case where the European Commission want to set aside a settlement which the European Commission itself agrees was not a fraudulent or a bogus settlement. They still wanted to set aside a trademark dispute, which is the settlement of 10 years ago.
No.
Don't trust them for a moment.
I see the point. Nevertheless, I think the courts have to develop their possibilities to deal with the confidentiality issue, especially in that's not our topic, but especially in the SEP cases where we talk about the outcome, which might be the outcome of independent negotiations between the parties, which are not influenced by the dominant position of the of one of the parties involved. Nevertheless, what we try to find in court proceedings the probable outcome of not influenced negotiations, and that I think that forces the court to find ways to deal in a confidential way with issues which are treated confidentially if the parties negotiate a license agreement. For instance, the condition of other license agreements with other parties, which involve trade secrets of third parties, and may influence the understanding of the license agreement you compare with a proposed license agreement in the case you have to decide. And I think that there must be a feasible way to deal with this issues which are quite similar what would happen if the parties really negotiated the question. Otherwise, the courts cannot compete anymore with alternative dispute solutions.
Ben Rigby from CDR. There's obviously a great deal of interest from corporate counsel organisations in ADR across a wide range of business sectors, including the life sciences industry. Does that strengthen the hand of those that want to encourage ADR on a number of levels, because it's very much an idea that its time has come amongst the corporate counsel community? I'm thinking here, for example, of the Association of Corporate Counsel, or bodies like CEDR and CPR, all of whom have made considerable strides in working with in-house counsel and the various institutions to encourage this, and it seems with some success.
Yeah, I can start to take that. So I think there is a bigger move in-house towards ADR. I think one of the difficulties, actually, even in using the term ADR, is that it's combining together arbitration and mediation, which are then conceptually, if you like, two completely different beasts. One very much adversarial, the other one much more collaborative. And I think that's one of the problems as well, perhaps also where legislation is suggesting alternative dispute resolution. Well, I mean, are you suggesting that the parties mediate, or are you suggesting that you take it out the court process and into an arbitration? They're two very, very different things. To my mind, I mean, I think we see relatively little mediation, frankly, within life sciences, or I have seen relatively little, and I think we are definitely missing an opportunity there. But we need to think about why that is. And there's a lot of things I think we need to change internally in order to be ready to engage in mediation in a more meaningful way. And on the arbitration side, yeah, I think it's always been a useful alternative option. And as we do more difficult, more complex disputes, more geographically challenging disputes, global disputes, I think there's probably more room for it.
Maybe just one last question, because unfortunately Latta Nieland was not able to attend, but she was raising one issue that seems to be quite of an interest in the Netherlands at the moment, that compounding issues, and there was even a discussion about the option of compulsory patent licensing going on. In fact, it's a topic about pricing again, and it's quite a sensible topic, I think. Do you think this could be open to ADR or especially mediation? I think.
I guess yes. If it's about prices, that's something you can negotiate. I would think. But to give a bit of context to Hanneke's question, it's a bit of how can I say, a public context where everybody, including politicians, because it's easy to yell that prices of medicines have become too high, etc., etc. Some, especially pharmacies and hospitals, have started to prepare generics in their fairly specialized pharmaceutical labs. But then the problem is, first those hospitals had 2 patients, and then after a couple of months it seems that the whole of the Netherlands has migrated to that hospital, and so sales dropped. But it's very much something that can be negotiated, but it has a very public dimension. And a debate that I think for pharmaceutical companies is very difficult to do in the open, because you become such an easy target, and so it's hard to, how can I say? I think mediation or in any event private negotiations could lead to a more reasonable outcome, probably. Yeah.
But again, you mentioned that it's a highly political and public issue involved. So I'm not so very optimistic that it's possible to resolve such a problem by any way of any kind of alternative dispute resolution. But probably might say that might have been an idea of the European Commission to raise this issue of compounding.
It might be. But where it came from, it was nothing to do with the people who were trying to make the court go.
I mean, also on that point, I think that the difficulty we have at the moment is primarily because of the combination of the pricing issue and the inability or the lack of desire to pay higher prices for certain products. The courts are now, both at a European level and at a national level, I think making bad law from a regulatory legal perspective in order to plug the gap. Yeah. So I think if it's possible to have a meaningful discussion on the pricing side that can resolve that, that would actually be hugely beneficial. Again, speaking in a personal capacity. I think that if we can resolve that, then we will maintain effectively the robust system that we have within Europe for marketing authorizations, for making sure that products are of high quality, are safe, and efficacious. And I think from that perspective, anything that we do on the regulatory side that weakens that is clearly a bad thing. So I would far rather have a mediation or some form of dialogue on pricing in order to avoid the sorts of decisions that are being made now at a local and EC level.
Right. Yeah, no, exactly. There's also a political, public debate that needs to be had, generally. Yeah.
From a theoretical viewpoint, you might say it's an ideal topic for mediation because you have a legal problem, which is not the real point, the real issue, but a symptom of a deeper conflict, and it's all about pricing.
Right.
So it's a conflict of interest.
The answer is not allowing unlicensed products that haven't been tested and no pharmacovigilance. Basically, that's not the answer. Yeah. Mm-hmm.
So, are there any
do we have time for a comment?
Sure.
not a question. It's touching on something that Gavin Pope said a little time ago, and which I would like to support. In my experience, the success of a mediation is so dependent on having business people in the room, business people who are authorized, not only authorized, but empowered. The lawyers there should be in a supporting role. The competing merits of the case can be, the legal merits, can be set out in the briefing papers, which are extremely helpful and important. But the real business of the mediation will be about business, and that's where you should have the business people there and as dispassionate as they can be. Mm-hmm. And then the chances of success are hugely enhanced.
Mm-hmm.
Could I follow on from Richard? Because I agree with him completely, but the joy of having some lawyers there is that when in the end you come to a conclusion, Then it's time for the mediator carefully to note at once, what has been agreed. 1, 2, 3, 4, 5. Get each side to go through it, you're all agreed, and then you look at the lawyers and say, thinking, haha, saves me a lot of trouble. Now, you two go away and write me a nice agreement.
That's normally at 2 o'clock in the morning.
Okay, maybe one last remark regarding these comments. What I really often experience in the life science sector is that the parties are really crucial about arbitrators and mediators having sufficient experience and sector experience. What they are really afraid of is having to explain again and again what the issue is, what the background is, and yeah, and this makes cases really difficult sometimes. Yeah.
And I think in addition to that, having arbitrators, and particularly a chair of the panel who has the procedural experience. Because if we want arbitrations to be, you know, fast and efficient, actually having a chair who can move things along, who can get the right balance basically between speed and efficiency and fairness to the parties, I mean, that has a huge impact. I think that's also very important, in addition to the knowledge of the subject matter area as well.
Good. So thank you all for the really vivid discussion.